Now to a heart-wrenching custody battle playing out before the U.S. Supreme Court. A baby girl ripped from the only family she'd ever known. Little Veronica, now 3 years old, was given up for adoption by her mother. But it's her biological father, who had no contact with her or interest in her from the first few months of life, who is now challenging that order based solely on his Native American heritage. And so far, he is winning. Trace Gallagher, live with the story. Trace.
And important to note that both biological parents gave up their rights to Veronica, and at 4 months old, that's when the biological father changed his mind. Under South Carolina law, Megan, he was not married to the mother. He stood almost no shot at all of getting this child back, but then he claimed he was a member of the Cherokee Nation, and under the Indian Welfare Child Act, he has the right to reclaim his daughter, and so far the courts have agreed. Now, the Indian Child Welfare Act was passed in 1978 as a way to prevent Native American children from being gathered up as they were and sent off to boarding schools and missions and away from their tribes. The almost adoptive parents of Veronica are Matt and Melanie Capobianco. Now, because of this appeal, their adoption never went through. They had Veronica for 27 months. They contend that Veronica is a multi-ethnic child and a small amount of Indian blood should not determine her future. Listen.
We understand the purpose of the Indian Child Welfare Act.
We feel that the ICWA law is being abused. You know, we don't feel that this was what it was meant for.
So a big part of this argument now is how much Cherokee blood makes you Cherokee. As Chief Justice John Roberts said, does one drop of Cherokee blood mean you have protections under the law? Does it also mean you qualify for benefits? So not only is the Supreme Court deciding this case, Megan, they may also be deciding exactly who's Native American and who's not. Megan.
Wow. All right, Trace, thank you. Kelly's Court is back in session. On the docket today, that case. Joining me now, David Wohl, a defense attorney, and Ashleigh Merchant, who is also a defense attorney. Ashleigh, let me start with you on this, because I understand you don't have a personal connection to the case, but you have a personal history that may be relevant here. Your thoughts on the fact that so far this Native American father has been winning at every turn?
Well, it's very unfortunate to me. I mean, I was adopted at birth, and my biological father fought my parents for custody when I was 2 years old. And I know that my parents went through a lengthy court battle to try and maintain custody of me, and luckily they were ultimately successful. But I think it's very unfortunate in this situation that this biological father gave up his rights to this little baby when she was born through what I understand through the pleadings, a text message, essentially had no part in her life, and then bam, all of a sudden changed his mind. And I don't think that that should be what determines parental, who is a parent in this case. I think that the parents who adopted this child should be allowed to have the adoption go through, and that this child should be able to stay with her parents.
David, this little girl only knew her adoptive parents for the first 27 months of her life. Only knew them. And then a court ruling came down in the biological father's favor, and he took her, and they never saw or spoke to her again. I mean, what does that tell you about this man's concerns about the best interests of this child?
You know, Megan, and what Trey said is exactly right. In 1978, the ICWA law was enacted because Indian children were taken out of Indian homes in the best interests of the child and put in white homes. And for that specific reason, that phrase, best interests of the child, was left out of the law. So the actual standard is, would it be emotionally detrimental to leave the child with the father? Now, the father did relinquish his parental rights, but 4 months later, he sort of instigated this legal battle, and that's where he's standing now. Megan, this law doesn't give at all. It's absolutely concrete. One drop of blood makes you an Indian.
Because he's got, that's about what he's got. It's three, he is 256th Cherokee.
Right.
As Justice Breyer said, he said that means you basically had 3 Cherokee ancestors at the time of George Washington's father.
And he didn't take care of the child. He didn't provide for the child. And that's not important in this law.
Right.
This
law was in place to prevent children from being removed from Indian families, not to put them back with an Indian family that had abandoned them already. This was specifically enacted to prevent them from being removed. And that's not what's happening in this case. In this case, the dad abandoned his child. A loving family adopted this child and was loving and raising this child, and arguably was doing so in the best interest. I mean, the lower court pleadings show that that family was loving and was supportive.
Yeah, there's no question about the love and the appropriateness of the Capobiancos. Right. But the question, David, is now they are alleging through their attorneys that if they continue to lose, if the U.S. Supreme Court, and we believe this is going to come down tomorrow or the day after, if the Supreme Court sides with the Native American biological father, that the end result will be you can never adopt a child who has even the most one drop of Native American blood in that child, because the Native American parent will always be able to come back and snatch the child from you.
Yeah.
What parents would agree to that? They'd be terrified of investing their love in this little person who could be taken away from them at any turn.
None, Megan, and I gotta tell you something. As opposed to most paternity laws now, where paternity is decided by support you've given the child, financially or emotionally, by other issues such as the love for the child or the bonding. Megan, race is everything in this law. That's what it boils down to. And the question is it detrimental to leave the child with the father? It's sort of a reverse argument. And that's the problem. There's no question about it.
This is
In
not a
1978,
How can that be the modern
that
day
was
law,
okay.
Ashleigh, that best interests
I
are
mean, when
irrelevant? Race 256 Cherokee, that's all that matters.
Right. You're essentially elevating an Indian, making someone who's of Indian heritage have more rights than any other parent, and that's not fair. And it's also circumventing the best interest of the child, which always has to be the law when kids are in place. And
Ashleigh, as you point out, as you point out, Ashleigh, the child has to be under that law in the custody of the Native American parent, and she was not.
Very
Megan,
big distinction. But as an adopted child,
As for Ashleigh.
You know, as an adopted child, I'm very concerned what this is going to do to adoption in this country. It's going to make these children, it's going to make it so hard for parents to adopt them because they're going to be terrified that this child,
and I want to talk about what's going to happen to this little girl. That's next.
We were there for the delivery and in the delivery room.
Yeah.
And Matt cut the umbilical cord, and we were kind of reeling from and reliving having to hand her over in our minds constantly.
Oh, my goodness, as you would. Now, in defense of the father, though, David, it took him a while. He apparently didn't have any interest in this child when she was in utero or for the first 4 months of life. But the reason the handover took place at 27 months without any contact was because he went from month 4 to 27 trying to get her back.
Right.
And the adoptive parents did not cooperate.
Right, and Megan, one of the reasons it's so difficult for the Supreme Court is there's no leeway in this statute. Look, there's no question, we all agree, this child is bonded to her adoptive parents. There's no question about that. But she can't say, she has no voice to say to the court, you know, I want to be with them. It's in my best interest to stay with this family because best interest isn't part of the law. It's unfair,
that's
but that's the way it was written because it's fair to the Indian tribes.
Let me ask you this, because now she was bonded to her original birth parents, her original adoptive parents, of course, and she was taken at 27 months. But now she's going to turn 4 in September. And the question is she still bonded to them? And, you know, now she's spent almost 2 years with the biological father, Ashleigh.
Right, and it's hard, and that's why these laws should always consider the best interest of the child. And essentially what this biological dad has done is use this federal law to try and twist and turn and gain custody of a daughter that he didn't really have any rights or any interest in at the beginning, and now she probably doesn't know which parents are which. I mean, she's been
Megan,
taken back and forth. My heart breaks for her.
And neither parent, you know, paved the way for her by allowing visitation with the challenging parent. I understand.
And that's it, Megan.
I understand the reluctance to do that. I really do.
There's
but
one solution,
come on.
Megan.
Quickly, David.
There's one solution, an open adoption. Whichever party ends up with custody has got to allow an open visitation schedule with the other set of parents,
court
and that would be
psychologists
fair to this
involved.
child.
Right.
We'll wait to see
And
what
if
the
this
U.S. Supreme Court ruling is. Should happen, we think, maybe tomorrow. Panel, thank you. We'll be right back.